Greetings. I am Cheryl Abrams Davis, your Maryland Realtors 2025 president, and I'm here today with 5 questions for our special guest, Secretary Jacob Day. Secretary Day leads the Maryland Department of Housing and Community Development and serves as a member of Governor Wes Moore's cabinet. As a member of the Governor's Executive Council, Secretary Day is the Governor's senior advisor on housing and place-based economic development and chief executive officer of the state's Housing Finance Agency, investing more than 2.5 billion, that's billion with a B, annually to revitalize Maryland communities and address Maryland's housing shortage. Since his appointment, Secretary Day has enshrined the administration's values into the department through the establishment of the Division of Just Communities, Division of Homeless Solutions, and the state's housing policy powerhouse called the Division of Policy, Strategy, and Research. He has also overseen the successful passage of the Moore Miller administration's groundbreaking housing package in 2024, where they financed more than 6,000 new housing units and provided $191.7 million in community revitalization projects across all 24 jurisdictions. In October 2024, House Bill 693 was passed, and the Renters' Rights and Stabilization Act was born. This act creates a number of additional protections and rights for residential tenants in Maryland, which is why I thought it was important to hear directly from Secretary Day. So today, we welcome you, Secretary, and thank you for being here to help us understand the key points of this act. Welcome.
Well, President Davis, thank you so much for having me, and so good to be with you.
Thank you so much. We're going to jump right in. So, tell us specifically what the Office of Tenant and Landlord Affairs does, and when should a landlord or tenant contact your office?
Yeah, so the Office of Tenant and Landlord Affairs is the product of that Renters' Rights and Stabilization Act that you mentioned. It's designed to help Maryland tenants and landlords understand their rights, navigate those rights and responsibilities under federal and state laws. For landlords and their representatives, and that can include realtors as well as property managers and other housing industry professionals. This is an office that is squarely focused on education, making sure that you know the requirements and how they apply and how to meet them, and how not to run afoul of any of the rules and regulations associated with that legislation and other existing state and federal law. And that includes this is an entity that's responsible for the education around the Tenants' Bill of Rights. And that's the new Tenants' Bill of Rights. This is a statewide addendum to all leases. And it's a critical change in state law that all landlords need to be aware of. And it also includes the right of first refusal process when a landlord wants to sell their property. If a landlord or other housing industry professional has a need for help navigating those requirements, our team, our new Office of Tenant and Landlord Affairs team, is ready and available to provide assistance. And we want tenants to also know what their rights are, and we want them to have the resources to help them navigate conflicts when they run into conflicts. Now, this is not an office comprised of lawyers. We don't provide legal advice or mediate disputes, but we can direct tenants to free and low-cost legal resources across the state, or refer cases where there seems to be a violation to appropriate local authorities. Now, also, if a tenant has the opportunity to purchase their home, the office can connect them to resources to make that easier and more possible or within reach, such as credit counseling and homebuyer education programs that help with the home buying process.
Wow, well, you gave us an earful there. So I'm going to back up just a little bit and go back to the Tenant Bill of Rights, which is actually very new to Maryland. It was part of the bill that was introduced or came into act in October 2024. But I believe that the date that we actually have to start using that Tenant Bill of Rights is it July 1st, 2025?
That's correct.
Okay, so what does that mean for any person, whether you're a direct landlord or real estate professional or property manager? When should that tenant bill of rights be given to the tenant? Is it at the time that the tenant has been accepted for the unit or the house? Or is it before that so they can know their rights before they even apply?
Great question. Great question. As envisioned by the law, the Tenants Bill of Rights is a summary of existing state and federal laws that apply to residential leases in Maryland. The time to provide it is as an addendum to the lease. So
Okay.
when the lease is offered for signature, that's the right time to apply it. Now, if a property manager, as they have applicants coming in, wants to send people to DHCD's website and provide it then, or even at the time of application, they're certainly entitled to. They're allowed to do that. It's now available. We have provided it. It's on DHCD's website. It's available in 18 languages. So
Oh,
there
wow.
ought not be a barrier to understanding what your rights are under state and federal law. But it is something that by law must be provided at the time that a lease is provided. It is part of every lease in Maryland now. And while you're right, this is new. As of July 1, this is a new requirement. There are parts of this state, like Montgomery County, the city of Salisbury, and other places that have had this for many, many years, decades, in fact. I also want to note that it doesn't include new requirements. This is not this doesn't create law. This is
Right.
simply a communication of the rights that people have that they're probably just not aware of, because most of us aren't legal experts, especially when we're doing something like signing an apartment lease. I don't claim that I knew anything about my rights the last time I signed a rental lease. It also doesn't include local requirements, so it's not specific to each jurisdiction. And there's no doubt that there are local rules and laws that exist in addition to those state and federal laws, but it's a baseline, right? It's a baseline. So it's now available on the Office of Tenant and Landlord Affairs website. It's in effect as of July 1. It's also going to be updated annually. That's one of the things that federal law, state law requires. And so going forward, we'll publish it every September in anticipation of October 1 implementation date. So this will be in effect as written for about 15 months,
Okay.
beginning July 1. And then in October 1, 2026, there will be a new version.
Okay, perfect. Thank you so much for breaking that down for us. Let's move over now to the owner's right to sell the property to the tenant when the tenant is already in place. I did read through the information on your website ahead of time. And so as I was reading, it appears that there are actually two ways that a homeowner can opt to sell the property to a tenant, and that's either via a tenant exclusive negotiation period or a right of first refusal. For the purposes of our members, I believe that that appears that there are two different ways that a landlord can give the tenant that opportunity. Can you go into a little extra detail and explain the differences between the two methods, and also let us know if there's some paperwork that the landlord has to file with your office in order to make it effective?
Yeah, absolutely. So the appropriate process, which of the two processes applies, depends on how the sale comes about. And so let me give you an example. I'm a landlord in a community in Maryland. I own a piece of property. I'm renting it out, and I decide I want to sell. Then both processes would be available to the buyer. They can consider it during the tenant and prospective buyer. Consider the sale during the exclusive negotiating period. And if they choose not to move forward, or if you can't agree on a price, then there is a point in time after there is an offer from someone else where the tenant has an opportunity to essentially meet that price within, and there's some details I'll get into in just a second. There's the possibility that an unsolicited offer comes in. That's a scenario that could limit the possibility to the second of those options, the right of first refusal. So the exclusive negotiating period is required if a landlord plans to list their property for sale. So if the landlord and tenant, they've got a period of time, 30 days to reach agreement on a sale price, and that's exclusively available to the tenant. But if they don't reach agreement within those 30 days, then a landlord has all the rights that they would otherwise have to list their property for sale. And if they list a property sale for 10% or less of the price that the tenant offered, an in writing official offer, the landlord has to then provide a right of first refusal notice as well to the tenant. To give you an example, if during that period a landlord offers to sell the property for $300,000 and the tenant counters for $290,000, so within that 10%, the landlord, let's say, declines that counter offer and says, "I'm listing the property for $300,000." Sits on the market for a while, and a landlord finally gets a third-party offer. It's at $270,000. They want to accept it. Since $270,000 is less than that offer that was offered by the tenant, and within that 10% difference then of the initial offer or listing price of $300,000, the landlord has to give their tenant that right of first refusal and give the tenant the opportunity to purchase the property at the offered price. So at the $270,000 offered by the third party.
Oh, wow.
The other scenario where a right of first refusal notice is required is if a landlord gets that unsolicited offer to buy their home and they plan to accept it. So if I put a sign on the house that I own, if I don't put a sign on the house that I own for sale, somebody comes to me and says, "Hey, I looking to get in the business, I'd like to buy that from you." Then in that scenario, whatever that offer price is, I have to give the tenant the opportunity to purchase it at that price instead of the third party.
Okay, so I have two questions for you based on what you just said. I know that there's a portal, there's an owner seller portal on your website with the state where when a landlord opts to make this option available to the tenant, they have to go into the website and there are some forms that they have to fill out. And then does that process start with the filling out of those forms for either of those options? That's my question. And then number two, what if the tenant doesn't want to buy the house? Can they just sign something saying that they're not interested?
Well, a tenant doesn't have to answer your question number two. There's no requirement to make an offer to own or to buy. The tenant doesn't have to avail themselves of this at all. So if you go to our website, dhcd.maryland.gov, right at the top, there's different constituencies, and one you'll see is property managers and landlords. And they can click on that. And for landlords, there is that portal you mentioned that has all the forms that they're required by law to send to their tenants to make sure that they don't want to purchase, or if they do, all of that detail is there. So you simply log in to that portal and you'll have access to all of that information. We also have email and phone number there on that page where they can go to get additional questions answered.
Okay, perfect. Now, since this is a new law and a new process, um, potentially, an owner or landlord may, reasonably not know that this is something new. So what happens, if the landlord or seller violates a tenant's right of first refusal, whether it's intentional or non-intentional? Is there a hand, is there anything that's going to happen to them if they don't offer this to the tenant?
So look, it's there was actually discussion during the 2024 legislative session about adding additional penalties, and everyone agreed that that was unnecessary. It's a violation of state law. There are fines and other punishments that will come down if somebody violates the law. So we're all subject to the law the moment it becomes effective, but we know this is a new requirement. It's an unfamiliar process. Landlords and realtors are going to have to navigate the partnership. So right now we're just hyper focused on education, which is exactly why you and I are having this conversation.
Exactly.
And we also know that realtors are the trusted advisors and experts in real estate industry to property owners. Look, I was a property owner and rented out my house when I moved away from the area. So I was a landlord in Maryland, had all sorts of things that I had to comply with,
Right.
and was not an expert. Trusting my realtor friends, picking up the phone was key. So educating realtors and helping them be experts to guide landlords is critical. In some cases,
Yeah.
obviously, some landlords are realtors, but in many cases, you just don't know. And so helping them guide their clients so that violations don't occur is step one. But yes, ultimately, under state law, landlords who don't comply with this requirement are subject to $1,000 fine per violation. So over the coming months, DHCD is going to establish a fine levy process and collection process and publish additional guidance. But our focus is going to be first and foremost on education,
Right.
helping people comply, not punishing people for not knowing
Okay, perfect. Okay, so we're going to move on over to security deposits because recently security deposits have been capped at 1 month's rent. However, there seems to be some exceptions where the cap could be more than 1 month rent. Is there any way that you can share those exceptions with us? There are very few, but I know that there are a couple of instances where potentially security deposits can be more.
Yeah, I think this is one of those areas that's tough change for some folks to accept, and it's understandable because it does represent um, the reduction of a particular tool that's used to recover damages. And obviously, we want to make sure that property owners are compensated when damage occurs through the courts and through whatever legal mechanisms exist. But Maryland is one of the most expensive states for a family to move into housing. We average $5,400 on move-in. That's something that most people don't have just
Right.
at the ready. And so this is an important change that the General Assembly adopted, and that was signed into law. Um, you know, Generally speaking, it's rare. There's almost no circumstance where a landlord is now able to charge more than 1 month's rent for security deposit. That also excludes like the first and last month's rent piece. I mean, you can't. There's that includes other fees. Like you're capped at a total of 1 month's rent. So I just want to make sure people understand that it's very narrowing in terms of what can be charged up front. So it's not a security deposit plus one first month's rent plus last month's rent. You can, of course, charge first month's rent and collect that up
Right.
front. That's logical, plus a security deposit. But there is an instance where a second month's rent can be collected. And that's where a landlord can charge that 2 months rent up front as a security deposit if a renter is qualified for utility assistance through the Department of Human Services, and if the landlord requires the tenant in their lease to pay utilities directly to the landlord, and they agree in writing on that amount. So if that amount is agreed on writing in the lease, tenant is responsible, pays the landlord, and qualifies for utility assistance, then in that circumstance only, a landlord can charge 2 months rent up front. And the thinking there, of course, is that there is more going on in this
Right.
contractual relationship than just the
The rent.
lease payment, but it's lease plus utilities. There's a lot going on, and the state is there to help. That's what the Human Services Utility Assistance Funding is for. So that's the logic behind it. Now, I want to note that again, this is one of those situations where we're working on education, but if a landlord charges more than that 1 month's rent, or in the case of a qualified utility assistance recipient, 2 months rent, then the tenant can recover up to 3 times the amount charged plus attorney's fees. So it pays in the long run
Right.
to just comply with the law.
Yeah, and thank you for sharing that with us. That was a very important piece for everyone to understand. Um, Question. So you talked about the cap for security deposits. Um, many people have pets, right? And pets are, family members for a lot of people. So can a landlord charge a pet deposit? And if not, what process is allowable to protect landlords when there are pets in the property?
Yes. So landlords are still free to charge a pet deposit or other fees like that. The difference is that it has to come from within that total amount
Yep.
of 1 month's rent. So it would reduce the non-pet related security deposit amount. I understand that this will have an effect on whether or not landlords allow pets. I think that is certainly one of the outcomes that could occur here. But I think um, the answer is simply yes, but it has to, the total amount collected has to equal 1 month's rent or less, with the one exception that we discussed.
Perfect. You've given us a lot of information to consider. You have some great resources on the website. So, can you, in closing, leave us with some of those resources and where people can go to get additional information about the um, offer to purchase from a landlord and again, the tenant bill of rights?
Yeah, so again, I'm going to direct your viewers to go to dhcd.maryland.gov. On that website at the top, you'll see property managers and property managers and landlords. In there, you'll find information about the Office of Tenant and Landlord Affairs, the Tenant's Bill of Rights in all 18 languages, downloadable, and then the information about the tenant opportunity to purchase and right of first refusal. I would also say take some time to look through some of the other resources.
Mhm.
Under homeowners and renters and developers and contractors, landlords will find other opportunities where for rental properties, we allow grants and loans for energy efficiency, for critical repair work. We have many of those programs that are not restricted to owner occupied homes and not restricted to the tenants as applicants, but rather you, the landlord, can apply for some of those resources to assist with repairs, improvements, and energy efficiency work to your properties.
Excellent resources. Thank you so much for giving us that additional information because some of that I didn't realize was on your website. So I appreciate you sharing that with us. We are immensely grateful for your time today and sharing this wonderful information that we now have to go and extract and do a little deeper dive. But this process today will give people at least some basic information to get things started if they're in that situation where they're working with a landlord who wants to sell the property to a tenant or dealing with a rental. And so, thank you again for your time today. We appreciate you very much.
I appreciate you. Thanks for your partnership. Thanks for all you're doing to help Maryland be a state that houses everybody who wants to be here.
Thank you. And we're going to let you know how things are going too. So, if we're finding that, we need to tweak a few things, I know where to find you.
We are not above improving upon wherever we're at. So let us know. Okay.
All
We're
right.
always
Thank
looking.
you so much. We appreciate you.
Thank
Bye.
you.